Hello, I'm Chris Schulman. Shortly, I'm going to do a mediator's opening statement, an example that you might use in deciding what to do in your mediator's opening statement. I say it's an example because the reality is um, what exactly I say varies a bit from mediation to mediation based on what I think the parties need and what the dispute may require. Um, but most of the time, they have most of the same elements that I'm about to use. One element that I don't typically include, but do occasionally if I think it's necessary, is I'll ask the parties if they'll agree to show common courtesy towards one another and not interrupt one another. Um, and then I ask for them to agree to that. Do they agree? I then wait for them to give me their yes on that. The reason I don't always do that is I typically only do that when I'm concerned that one party is likely to make an outburst and to interrupt the other, which I may have learned during my pre-mediation brief consultations that I typically do with each side. And now I'm going to do my mediator's opening statement for you. Hello, my name is Chris Schulman. Thank you very much for selecting me to serve as the mediator in this matter. As you may know, mediation is an opportunity for both sides to sit down at the table and with the assistance of a neutral third party called the mediator, I, I'm the mediator, try to see if we can help you folks work out the dispute that's currently pending. That's important to recognize. While I'm a neutral third party, I'm not here to make any decisions whatsoever. Instead, only you folks with the assistance of your counsel can decide whether and under what terms to resolve things here today. If we reach agreement, great. Type it up, print it out, sign it. It'll become a binding, enforceable agreement from that time forward. If we don't reach agreement here today, well, that's okay. I'll simply check off a different box on the form the court has me file, indicating that we met but weren't able to reach a deal. Although, frankly, I hope I get to check off the box that says we did reach a deal here today. We're here to have a conversation. We're to talk things over to see if we can work things out. And to help everyone put their best foot forward in these conversations, essentially everything we talk about here is confidential. I do say essentially on purpose because there are very few exceptions provided by Florida law, things that frankly don't apply to the vast majority of mediations that I conduct. For example, if someone were to talk about child abuse, or if someone were to talk about elder abuse, or if someone were to tell me they're going to commit a crime and I believe them, well, that sort of thing isn't confidential. So let's not talk about any of that stuff, and everything else will remain confidential unless disclosure is either required or permitted by law. Let me tell you a bit about what to expect here today. Shortly, I'm going to ask each side to make brief opening presentations to me and to one another. That's typically done through counsel. And the purpose behind those initial discussions is to set forth your respective understanding of the events that have led us to be here today. But more importantly, it's to begin the conversation we're actually here to have, which is what it might take to resolve the dispute. Now, I only know a little bit about this dispute, the little bit that I've been able to glean prior to our starting here today. So I will likely have some questions for you, questions that are designed to bring me up to speed and put me in the best position to help you see if we can work something out. At some point, though, typically my pattern is to split the two sides up and meet privately with each side. And what we talk about in those separate sessions, I'm required not to share with the other side unless you give me permission to do so. Having said that, when we're in those private meetings, please don't be surprised if I ask you for lots of permission to share lots of the things we talk about. And the reason for that is, in my experience, I've done more than 3,900 mediations. In my experience, cases are more likely to settle when the information is flowing freely between the two rooms. So as I say, don't be surprised if I ask you for that permission. I'm almost done. You know, there's a mediator I know who says that the mediator is talking, especially at the beginning, not a lot of work yet. So I promise I'll be quiet real soon, and we'll get started with the hard work we're here to do, which is to see if we can settle the claim. But just a few things to say by way of conclusion. So I mentioned before that I'm a neutral third party, but that I'm not here to make any decisions. Part of that means that as a certified mediator, I am literally prohibited from predicting what I think the court will do in this case if you're not able to reach a deal. But what I can and will do is talk about potential outcomes. What might happen if this happens, sort of thing. We can talk in general ways about the relative strengths and weaknesses of the claims and defenses that have been brought here. I can ask questions. Now, before I said I'd ask some questions to help me understand better where each side is coming from, and I certainly intend to do that. But I can also ask questions that are designed to challenge assumptions that may be leading each side to take the positions you take here. We sometimes call that playing devil's advocate. And please understand that if I do play devil's advocate, it doesn't mean I'm on the other side. It just means that I want to promote a robust discussion of the issues, all with an eye towards seeing if we can get a deal here today. And along those lines, what I can and will do is to make suggestions about offers or counteroffers that the parties might make to one another. Um, Again, I'll just try to see if we can work something out. Of course, you don't have to take my suggestion. It's just something else for you to consider as we go through the course of our discussions and you decide whether and under what terms to settle here today. Folks, this dispute's been going on for a long time. My goal is to help you folks reach a resolution here today that will make today the last day of this lawsuit. To help you folks reach a resolution that both sides can live with, that you can move on with whatever is next in your respective lives. I'm here. I'm committed. I'm going to give you my level best effort to help you folks reach a resolution. But at the end of the day, whether literally or figuratively, if there's a deal and what the terms of that deal might be is in your hands. And having said that, I will also say that in my experience, cases are much more likely to settle when both sides are willing to make some compromises. So it shouldn't surprise you if during the course of our discussions, I ask you to make some compromises. Okay. So before we get started with your opening statements, are there any questions that you have about the mediation process, what it is we're here to do? No? All right. Well, then we'll hear from the plaintiff.